to have Treasurer Slavens be the clerk for today, as Clerk Seegers is working on the election today.
I'd like to make a motion to make Treasurer Diane Slavens the clerk for the meeting.
Support.
Motion made by Summer Foster and supported by Kate Borninski. All in favor say aye.
Aye.
Opposed, nay. Motion passes. Okay, so Diane, can you please take the roll call?
The board, Borninski,
Good evening.
Foster,
Good evening.
Ganguly,
Good evening.
and Hudak.
Good evening.
Sechrist is working on the election. Slavens, good evening. And Snyderman.
Good evening.
And roll for the Planning Commission, Cruz. Here. Eggenberger,
Here.
Foster,
I'm here again.
Jankowski is not here. Lee. Here. Singh. Here at the moment. Watkins isn't here. Weber.
Here.
And Zuber is.
Can I have a motion to adopt the agenda, please?
Supervisor, I make a motion that we adopt the agenda.
Support.
Motion made by Treasurer Slavens, supported by Trustee Ganguly. All in favor say aye.
Aye.
Opposed, nay. Motion passes. Can we all please rise for the Pledge of Allegiance? Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, great. Thank you. Yeah, I think mine's just vibrating. Thank you. All right, today we are going to be doing a study session on tree and woodland preservation ordinance update. That's really strange.
I have no knowledge area there.
Okay, all right, there we go. All right, so that was a big introduction. So we're going to be talking about our tree ordinance, and Patrick, if you wouldn't mind just taking it over and introducing us to the guest and get us started.
Mic on. We were honored to have that opportunity to work with Professor Norton and his students in the environmental planning class, which we did last semester. Both Zach and I had taken an active role with the class, working with the class, presenting at the class, and receiving the final presentation and ultimately the final report. As an aside, Zach and I are both Michigan alums, so it was great for us to go back to our grad school and participate there. So just had to get that plug in there.
Zach is our arborist. He's basically our expert arborist on the Township Planning Committee.
Yeah, Zach, he's works with us. He's with us in the planning division and our resident tree expert. In the presentation and some of the materials that have been distributed, the report from the U of M students is included. And it's already added a lot of value to the things that we're doing, and it'll continue to add value to a lot of the township initiatives that we have going on, including our master plan, our tree ordinance, and some of the things that we'll be doing with tree planting in terms of future plantings. The draft tree ordinance itself, it's still very much a work in progress. There's still work to do. And the draft ordinance itself and a cover memo were previously distributed in the packet. And we can refer to it later as time allows. Otherwise, we'll be looking at it a lot through the process and discussing a lot of the elements of it. Some of the major elements, including some of the areas that we highlighted in the ordinance, as well as some of the tree mitigation options. The main purpose for this evening is for Professor Norton and Jesse to give their presentation, and that presentation will describe where we are, how we got here, and how we can proceed. And just as Canton Township was an example of how tree ordinances sometimes don't work, we want to strive forward on being an example of how it can work and how we can use best practices, both preservation practices and legal practices. So before we begin, I don't know if you have anything to add or.
Something that's obviously been in the air around here. Know that there are lots of people around the state and the country looking to see what we do and how we do it. We've gotten calls from folks as far away as Tennessee who are in our same federal circuit court asking, what are you guys doing? So this is kind of exciting that we get to lead the way with all the expertise we've been able to assemble for this. And parking on North Campus is still back in the day.
I can attest to that. So without further ado, Professor Norton and Jesse can take over, introduce themselves, and give their presentation.
Can you hear me okay? A couple of initial things. So I'm a planner and a lawyer. I work with the Michigan Association of Planning on their planning law committee, and every so often we'll file amicus curiae briefs, friend of the court briefs, on decisions that are coming up to the Michigan courts, and in this case, the federal courts that have a huge implication for planning practice around the state. And we were approached by your counsel after the trial court cases to see if we would file amicus appellate briefs, which we did for both the Sixth Circuit Court of Appeals and the FP development decision and for 44650 and the Michigan Court of Appeals. You should know that where you got caught with your tree ordinance was a pretty novel legal argument. In fact, there are no federal cases that do what happened in this case, that speak to it directly. And there was one single state case decision. It was a Texas Court of Appeals decision that the courts honed in on and grabbed. And I think, frankly, they misapplied the law. But you got caught. And so you're making waves, whether you wanted to or not. The cool thing is, I think, to speak with what Patrick's talking about, after this all happened, I've been asked to give these presentations, so that what I'm giving you is more than, you already know a lot of this, but usually the audiences I'm speaking to don't. So I go into some details. So I'm going to move pretty quickly. But I'm happy to stop and explain everything. If something's confusing, just yell out. I'm happy to stop and explain. The cool thing is where you're headed in taking the lemons that you got from these decisions and turning them into lemonade with a really good, robust tree preservation ordinance that's also legally defensible is really cool. And so we're continuing to work. The student project report we did with you all, and thank you for letting Zach and Patrick spend time with us for our class efforts. It was a really good learning experience for the students. And we're producing products from that frankly I hope to get out and share with the rest of the world to say, look how they turn this into a good thing. So hopefully you will become a model of here's the right way to think about it and do it. So I wanted to just start off with that. And please interrupt me if anything comes up. I'm happy to chat. Trees are good things. I'm not going to dwell on that. You all know where you are, but usually I have to explain to folks where you are. There are a lot of facts here. I won't dwell on them. I just want to point out, I think the two facts that just really stuck in the craw of the courts, frankly, that drove a lot of what happened here was the fact that 44650 bought their 16 acres for $404,000, and then they clear-cut everything, and then the tree assessment fees that the township leveled against them were $446,000, more than what they paid. the courts quickly concluded, clearly that's a regulatory taking, and I'll talk about that more in a minute. I don't think actually it was, or there was a really good argument that it wasn't, but the way the legal theories played out, it was easy for the courts to go there and just decide this was too much. That was the fact, though, that I think was driving this all the way around. You know your past tree ordinance. It applies to regulated trees and landmark trees. The sequence that the ordinance lays out is to try and, first of all, avoid trees if you can. If you can't, try and replant on site if you can. If you can't, try and replant off-site if you can. If you can't, pay into our tree replanting fund and we'll plant off-site. So here are the pretty clear purpose is to try and maintain the existing trees and the tree canopy that the township has through these mitigation measures. So another thing for you all to know is overall, I think the ordinance that you were working with is pretty typical. We've looked, Jessie and her team, her sub-team on our group, looked at a lot of ordinances. And what you had before is pretty common for what other communities are doing out there, which frankly has a lot of those other communities pretty scared because, oh, look what happened to you. We don't want to end up in the same boat. There was one piece of this that didn't actually get litigated that I was pretty nervous about when I first came up to speed, which is your exclusion of lots smaller than 2 acres, which Jesse will show you a graph later on in the presentation, has the effect of excluding the vast majority of property owners in the township from this regulation, which is kind of good politically. You're only hitting a small number. But from a regulatory takings perspective, that's not such a good thing because you're really focusing all of your mitigation efforts on a very small number of property owners, and that makes courts get nervous. Like you're picking out some people and treating them unfairly compared to everybody else. So that's something that you'll want to contemplate as you work through revisions to your ordinance. Who is this applying to and how do we make sure it's fair? Okay, I have to tell you, the attorneys who represented the property owners in this case came up with some pretty novel legal theories. That they were kind of throwing everything out there to see what they could get to happen. They alleged a taking of trees in violation of the 4th Amendment, excessive fines under the 8th Amendment, and then a couple different theories of regulatory takings, and I'll explain that in a minute. All of the appellate courts dismissed those kind of far out 4th and 8th Amendment claims. So really, this case boiled down to what's going on with regulatory taking. And the trial courts, there are a couple different flavors of regulatory taking, but the pivotal one became an unconstitutional conditions case, and I'll explain that in a second. I'm going to skip through this because the text is all there and you've all been through this, and I'll explain this in a moment. But both of the trial courts, federal court and state court, found that the ordinance with regard to these 2 property owners affected a regulatory taking of their property. One of the courts found that it was based on one theory of just an unreasonable burden. Both courts found it was based on what's called an unconstitutional condition. The appellate courts, the way they reviewed these cases was they kind of set aside all of the other stuff except the unconstitutional conditions claim. So that's the only binding law that we now have to deal with. The appellate courts established new law that everybody's got to comply with. So you're getting calls from Tennessee because they're part of the 6th Circuit. They're now bound by what the 6th Circuit held in this case. And every municipality in Michigan is now bound by what the Michigan Court of Appeals found through its litigation. And they both honed in on this particular legal theory. So those who are planning regulatory takings. I'm getting there. Yep, I'm gonna explain that in a second. This is detailed. Basically, the other thing you all know that I have to explain to folks is it was the same set of legal actors, right? You had 2 property owners, but they were adjacent to each other. They were represented by the same counsel. You had the same counsel representing you. All of the legal arguments were the same, even though there were 2 different property owners. So there's a whole lot of parallels in the way the courts treated these things. I'm going to skip. Okay, let's talk about a regulatory taking. This is the confusing part. So the first thing to know is the traditional legal protection that starts all of this discussion off is the taking clause in the 5th Amendment to the U.S. Constitution. Nor shall private property be taken for public use without just compensation. This was a protection baked into the first 10 amendments, the Bill of Rights, that recognizes the authority of government to take private property, but it's a check on the abuse of that power, right? The Bill of Rights recognize the government has the need and the authority and the prerogative to act. We don't want it to do so in an unreasonable way. The takings clause, the example I give in the classes I teach is, you've got 40 acres, the government knows it needs to build a new highway, it's going to have to take the back 10 acres of your 40 to build a highway. That's a public use. The only question is, how much do they have to pay you for it? That's going through a formal condemnation action. Does that make sense, everybody? Governments, you all probably know this, hate to condemn property because it's so contentious. But it happens, and you have to do it sometimes. That's the idea of a taking under the Fifth Amendment. Another protection that's in the Fifth Amendment is the Due Process Clause. Nor shall government, through its regulation, take life, liberty, or property without due process of law. The government can take your property, it can regulate it, it can take your life, it can take your wealth, but it has to follow due process. It has to justify why what it's doing is reasonable and necessary. That's the protection. You with me so far? Early on, so a due process calculus is usually kind of figuring out how burdensome is this regulation on this property owner, and is it necessary? Is it a reasonable thing to do, and is the way the government doing a reasonable way to get there? For the most part, governments, usually when people litigate governments, they're going to lose. Governments usually, especially now that all of these doctrines are laid out, and counsel can advise you, don't do that, you're going to lose. Governments don't tend to regulate in ways that are going to draw legal cases. So usually, due process claims that come up to the courts, the government usually prevails. Early on, the takings clause was understood to only apply when government's going to take 40 acres to build a highway. Nobody ever thought that a regulation could now somehow become a taking that's brought under the Fifth Amendment until 1922 in the Pennsylvania coal decision. I won't go into the details, but basically the state passed an act that regulated the removal of coal. A property owner was unhappy. The Supreme Court said, you have regulated this use of property so much so there's basically nothing they can do with it. When you regulate that far, you've basically taken the property. You're just doing it in a sneaky way. Instead of condemning it and paying them for it, you're regulating the use away and you're getting away scot-free. That's the attitude that the court's taking here. We're worried about abusive governmental action. This is a backdoor, sneaky way to take property. The famous phrase in Pennsylvania coal is, when a regulation goes too far, it will be deemed a taking. Justice Holmes, one of our most famous justices, was famous for making these really pithy legal quips that kind of sound good on first cut, but then you have to stop and think, what does that mean? How do you know when a regulation has gone too far? We've killed so many trees, writing legal commentaries and cases, trying to figure out what does that mean, and there are now different legal doctrines out there that kind of explain what does it mean to go too far, different flavors of regulatory taking. The key concept here, this is probably the most important phrase in these slides, the regulatory takings doctrine serves to bar government from forcing some people alone to bear burdens which, in all fairness and justice, should be borne by the public as a whole. If you're hitting the example I use in class is there's a special protected butterfly habitat. Turns out you have one property owner in the community that has that. You pass a law that says you can't do anything with your property because you've got protected butterfly habitat. You've done through a regulation what you should have just bought the land and turned it into a refuge, right? That's the concern of the courts. So now we have this doctrine out here. When a regulation is too burdensome and it's forcing a small number of people to bear burdens which the whole community should bear by buying the property and paying for it through public funds, that's when you run afoul of the regulatory takings doctrine. That's the doctrine writ large. If you force property owners to let people under their property, that's an ouster, that's a taking. If you take all of the economic value of the property, no ands, ifs, or buts, that's a taking categorically, if you get there. I think, frankly, that to go back, I think the courts looked at the fees that were assessed against 44650 and said, well, clearly that was more than they paid for it. You've taken all the value. I think that was actually contestable because there's still a lot of value left in that property. And for whatever reason, that evidence didn't get in front of the courts, but it was easy for them to just go there. So that was an issue. Usually, most taking cases are adjudicated through the Penn Central test, which is basically a balancing test. How burdensome is the regulation? How important is the regulation? What are the economic opportunities? And usually courts find under Penn Central claims that the government's going to prevail. Again, you don't usually find successful takings claims, except in the most extreme cases. And then we get this one quirky new theory of a taking, the unconstitutional conditions doctrine. And I'll try to move through this quickly, but this is the case that just gummed everything up. And I think the fact that the court here went here with this theory and it hadn't been applied before is what threw the township, frankly, for a loop. You didn't see it coming. Nobody saw it coming. Nobody else had litigated this before. This is a novel application. The idea is sometimes government doesn't go to a property owner and say, you can't cut down trees. It says to the property owner, you can cut down trees maybe in exchange for a permit, but we'll impose some mitigation. We'll give you the permit to build, but you have to give us something back. And the idea behind an unconstitutional condition is you can't compel a property owner to give up a right, a constitutional right that they have in exchange for a permit unless there's a really good reason to do that. The courts recognize there's some benefit to getting a permit, right? You're allowing development to happen that's probably going to increase the property value. You're imposing a requirement on them that takes something from them, but on balance, maybe that's okay. We're going to come up with some tests to figure out if that's reasonable or not. Here's the catch. All of the case law that's dealt with unconstitutional conditions has been demands from government that you give the property owner give up an easement. We'll give you your permit to build. You need to give us an easement so that the public can get to the ocean front that's in front of your property. Or you need to give us an easement so that we can add to our bike trail system. And that's going to become public property. Go back to my example of we're going to take this land to build a highway. That's a taking, right? Now you're doing a taking, except you're doing it in the guise of a permit. Does that make sense? That's where the courts get troubled. I don't think this doctrine applies when you're just demanding mitigation for harms. That was the novel expansion that happened in this case that I don't think anybody saw coming. But the courts bit into that on this case, and it just kept going. Yes, sir. Yeah, so that's a good question. When you grant over an easement to the government, you own the underlying rights, but the public has now a public right of access and use across, right? So if you put in a bike trail, the property owner can no longer say, you can't come on my land, you're trespassing, you have the right. That's a title interest to property. And you're forcing a property owner to give that over in exchange for getting the permission to build. And that's one thing the courts really get nervous about is when you tell somebody you have to give up the right to exclude others from your property, that's a pretty quick taking. They're going to go there. You can't do that. Except sometimes the benefit of what's being demanded, that it makes sense. What you're demanding and the easement you're requiring makes sense in the context of what the development is. And so the courts have come up with this two-part test. There needs to be an essential nexus, that's fancy Latin legalese for some relationship between what you're demanding and the harms that are going to be created, and there needs to be rough proportionality. So this was easy, the essential nexus was easy here. If someone's taking out trees and you're demanding that they plant trees to replace them to mitigate that, nobody ever questioned that that was a reasonable way to mitigate the harm. In the one case for the easement, the argument was you're adding new space to your hardware store that's going to create a whole lot of demand, and people can use their bikes to get there. It's not unreasonable for you to let us build on the bike trail to allow them some additional access. You can debate whether that was true or not, but that was the argument that was made. So the essential nexus part of the test was really never in question here. The big question was rough proportionality. Is the amount of mitigation or the demand that you're making roughly proportional to the harm that the development would cause? And if it is, the court said it doesn't have to be mathematically precise. It doesn't have to be 100% accurate. It doesn't have to be the only kind of mitigation you require. But if it's roughly proportional, it's okay, you can make that demand, you're not going to have a regulatory taking. But if it's not roughly proportional, if you're demanding way more than the harm that's being caused, then we're going to find a taking. Is that making sense? Okay, so here's the problem. I think that the plaintiff's attorneys in your cases kind of made the quickest statement that anytime you require a permit and you demand anything, that trips the unconstitutional conditions requirement. When we started looking at that, the planning law committee, and saw what was going on, our first reaction was, no, that's not right. They're getting away with something here that they shouldn't have gotten away with, that the trial courts just accepted. So one thing you ought to know about this case too is this is really arcane law. This is like super specialized. And most judges were like criminal lawyers. They maybe didn't even take property law when they were in law school. And a lot of attorneys who litigate these things, they're worried about HR kinds of stuff. That's their bread and butter. Land use disputes just don't go up in front of the courts that much. And so there's a whole lot of room for misinterpretation and misunderstanding of what's going on. So they got away with kind of making this claim that the unconstitutional conditions doctrine applies here. And having gotten the court to say yes, then they basically argued the fees you're assessing against these property owners is too much. The dollar value of the mitigation fees even exceeds, in the one case, the property value. How could that be anything but a taking? That was the thrust of the property owner's argument. Legally, though, the problem was your ordinance didn't do anything to provide any justification to a property owner about why this was a reasonable thing to require. That's where you fell down. And oh, by the way, your ordinance is pretty typical of other ordinances out there. It wasn't like you were doing anything unusual compared to what everybody else is doing. You're the ones who got called on the carpet because of the way it played out, given the facts in this particular situation. So what happened? Was it ordinance design? It looks to me, when I got involved with this, I was quizzing, like, where did this ordinance come from? And I think everybody had moved on. It looks to me like someone found it on the web and tweaked it a little bit, and you all just adopted it. It's been here a long time, and you don't have any plans to justify what you're doing. Even the ordinance is pretty silent about why are we doing this, and why are the mitigation requirements for imposing reasonable things to require. There was just no background study in the way it was designed. You exempted a huge portion of the township from it. That actually didn't get litigated, but I was really nervous that that might come up because that would have cut further against you. There were provisions in the ordinance that allowed for some tailoring, but the courts didn't see it that way. They just saw it as kind of a preliminary thing that didn't really allow for tailoring the mitigation requirements. They dismissed those pretty quickly. Yes, sir.
What's this one?
Trevor did say your phones, if you would remove them from near the microphones, he
right.
thinks you're hearing also.
I went on substantial exemptions. So as far as I understood, it was 2 acres or less, like you mentioned. So that kind of, in my mind, restricts us penalizing individual homeowners from removing a tree that they don't really usually have to get a permit. And but as I understood it, because I think we did ask questions about that originally. It's been a while, but of course the developers that develop the subdivisions that those homes are in are creating neighborhoods out of properties that are quite larger than 2 acres. And they are restricted under this. So the trees, that seemed to be where the issue was with people clearing trees. Individual homeowners rarely remove big trees, but developers do.
Yep.
So,
Yeah,
what I'm asking is that kind of doesn't exclude that property. It only excludes it after the development is already built.
Yeah, and in my conversations with your prior counsel, she kind of laid that out, that was the reasoning. And had this issue come up in front of the courts, that would have been the response. There's a logic to why we're doing what we're doing. But frankly, given the way the courts treated the facts, I would want to have a better response than that. And I don't think, so let me be clear, I don't think you necessarily need to regulate every property in the township. but you probably want to regulate more than just the really big landholders and exclude everybody else. There's some happy medium in there. And again, Jesse's got a series of graphs to show you that it's just something for you to think about. And the courts, I can't predict how a court will deal with this because it's only going to happen when it comes up on the facts. Where this issue has come up regularly is in wetlands regulation, because not everybody has a wetland on their property, but if you have wetlands regulations, it applies to a smaller, some subset. And for the most part, the courts in Michigan have been pretty okay that enough people have wetlands and we're regulating them reasonably enough that passes the smell test. So where you need to decide is what's the right threshold to use so that we're spreading this out. It doesn't have to apply to everybody, but there's a good distribution of who's having to do this and a good justification for why. So I'll never tell you, you need to set a threshold here. I'm just pointing out that's a weakness I think that you might want to think about as you plan ahead on fine-tuning your ordinance. And just be prepared that could be something that someone litigates on. Does that make sense? Yeah.
So as you said, I mean, most of the people that created the ordinance are gone. I mean, this was done many, many years ago, and we've inherited this. I mean, even the previous administration came up with the amounts to charge, and we're dealing with the backlash of this now. So when I look at your design problems and you talk about unconstitutionality, is it basically because of this, or was it deemed unconstitutional because of the cost inside the ordinance only?
Well, no, it was really because you didn't justify your mitigation requirements.
Okay.
That's what. So let me keep going, and I think it'll play it out. But I see other hands first. Yeah.
No,
Yes,
I
ma'am.
was, and I think you may be going here, so if you are, feel free to tell me that. The first one is no background justification. So are you saying, like, in the beginning of the ordinance, we need to spell out why exactly we feel the need to protect trees in the community to address flooding or climate and...
Yeah. So a couple of schools of thought. Some people believe ordinances should only have just the requirements and none of the background justification. But more and more people are adding the background justification because that's what the courts look at, right? So I think, and your draft ordinance that you're working on is adding a whole lot of that justification that wasn't there before. I'm not your counsel. I should have said this from the start. I am not your legal counsel. So you can take anything I tell you with a grain of salt and just dismiss it out of hand. But I think it's a good thing to provide those findings at the upfront of an ordinance. And then the planner in me is, and link them to the good planning studies you're doing ahead so that it's really tight. You've done some planning work, you've done some collaboration with your community members. They understand and get why we're regulating who we're regulating, why we're protecting trees. You've got that background plan, forestry plan. You've got that really tightly connected to the findings in the ordinance. Now the measures in the ordinance start to make a whole lot more sense and provide that kind of justification.
So not only does the current ordinance not have any intent and purpose or findings, but our master plan, if you pull it up as a PDF, you do Control F and you type tree, it doesn't mention tree. It says street twice, but it doesn't say tree anywhere. So we don't have a policy reason of why.
Not unusual again, but wow, when I first looked at this, there's nothing in your plans that says anything about trees. Oh my gosh. Yikes. Yes, ma'am.
So I just want to understand, you said it's a very common ordinance, like this is how usually, so I think you were telling us that the reason that we were caught or the courts ruled against us was because of the proportionality thing. That was the main thing.
Yep. Yeah, well, it was the proportionality and really the fact that you didn't justify why that was a reasonable mitigation to impose because of the harm that was caused by taking out all of those trees. So, and that's kind of where Jesse, my colleague, is going to step in.
I do have
Yes, ma'am. Yeah.
one more quick question about the other ordinances in Michigan, the other tree ordinances. I assume they weren't all struck down because of the court finding.
No, but so this is why there are so many communities in Michigan that really want to know what you all are doing.
Yeah.
What happened and what are you doing? Because they want to see, are we administering our ordinance in the same way that we could get caught up on the same way? And there are ordinances in the state that are in better shape than yours, frankly, that hopefully yours will be in as good or better shape when all of this is said and done. Grand Rapids has done a whole lot and has a pretty robust program going. there are a handful of places that have done a little bit better job. We didn't find anybody that's really laying out in gory detail the justification like we're now suggesting that you do
Okay.
in response to the decisions that came down in your cases.
That was the next part of my question, so
Yeah.
thank you.
Yep. Yes, sir.
Done a few developments in Ann Arbor and very strict. I remember the mitigation. How does that compare to ours? And did they justify?
They've done
their
some,
ordinance.
yeah, they've done some more planning background work, and I think they've linked a little bit better to their zoning code, but they're paying close attention to this as well. Just because a community hasn't been litigated yet doesn't mean it would lose. It just hasn't been litigated yet. So I'm not sure I would tell you. Yeah, I don't want to. I mean, I'm happy to tell you your ordinance is pretty typical of a lot of the ordinances out there. There are ordinances that are dealing with this better. And this case law is going to drive communities to go back and revisit how are we doing this and how do we make sure that what we're doing is really justifiable. And I think it is. I think having good tree protection ordinances and what you're trying to do is justifiable. You just have to go through the hoops. It's kind of like being a professor. My students may know the work that I'm teaching them, but I don't know that they know the work until they take a test and they show me they know the work, right? If you don't give a court what it needs to know that what you're doing is reasonable and fair, it's just going to assume what you're doing isn't reasonable and fair. You haven't proven it to me. That's what happened here in a big way.
And for some of those reasons, our draft ordinance, about the first 6 pages deal with purpose, intent, and statements of why trees are important. Some of it is kind of basic information, but it'll set the stage for everything else that we do. And it may seem like it's a little over the top and reading less like an ordinance and more like a plan, but those are some of the reasons is, especially if attorneys or judges are not familiar with tree ordinances or municipal zoning ordinances as they are, this would kind of give a little bit of a precursor in terms of the why.
I keep going? Okay. So that was the design. There were some administration problems, and this came out through deposition testimony with planners who I think have since retired. But basically, they just said in deposition, well, we just apply it. There's a ratio where you apply it. If you cut down a tree, you have to replant a tree. They weren't using the ordinance as they might have to kind of tailor the mitigation to fit the circumstances or take account of extenuating circumstances. It made it really easy for the court to say, you're not doing what you're supposed to do. And then defense problems. Nobody questioned, is the unconstitutional conditions doctrine even applicable here until it went up to the courts of appeals. There's a general rule by courts of appeals, if you don't litigate an issue below, at the trial court level, you lose it, because we're only passing judgment on what was litigated and the parties had a chance to argue. So in a way, I think I talk about this later, the Sixth Circuit basically said, well, this question has come up about whether this doctrine should even be applied, but the parties didn't raise it, because MAP raised it, and so since they didn't raise it, we're just going to set that question aside and keep going. So I would still question whether, in fact, that doctrine was properly applied to. I think there's a good argument that it wasn't. Having said that, it's not a bad thing to justify to your property owner why you're making them replant trees, right? There's nothing bad about what we're suggesting that you do. That it just isn't good part of good planning and regulatory practice. Okay, there were some litigation challenges. These are arcane legal doctrines. It's really confusing. How do you value a tree? There's a whole lot of work about there. What does that mean? And frankly, I think the courts were they came into this with the wrong perspective. This is a quote from the trial court judge in the federal court system. Well, you're requiring that people protect trees on their property. Clearly, that's a balance should be shared by the community as a whole. That's a policy choice. Courts are not supposed to make that policy choice. They're only supposed to be checking to make sure that you're not being abusive. I think the courts came into this whole thing with trees are things that are fluffy aesthetic concerns, and if you're going to regulate them, then you should have to pay for it, government. That was an improper posture for the courts to take from the start. Frankly, the state trial court was even worse. I mean, just clearly wasn't buying that there's a good justification beyond just aesthetics for why you're protecting trees, and if you're going to make a property owner keep them, then you should have to pay for it. there are lots of good justifications to maintain trees and tree canopy. Here's the key thing, and the things this is what it all boiled down to. Just look at the highlighted. There's no evidence in the record, completely lacking from the record. There's no individualized assessment demonstrating that the mitigation required is roughly proportional to the harm that's done. It wasn't the case that what your property owners were doing was benign. They were kind of found not guilty by the courts, not because they were doing benign things, but because the township didn't demonstrate they were doing harmful things. You didn't have baked into your system a good justification for why trees are important, why, if you have to take them out, we want you to mitigate to restore the functions that you've deprived. That's what this is all about now. How do we bake into the system good justifications so that you can be sure what you're requiring is reasonable, and having done that, a property owner is going to say, yep, that's reasonable, or if they litigate, the courts are going to say, yep, that's reasonable. You may not like it, but that was a reasonable thing for the township to do. That's where all of this is headed. Does that make sense?
I just have one question, and I'm actually kind of stunned by this. As Supervisor Graham-Hudak stated, nobody that worked on these ordinances are still here, and I can understand, like, in the ordinance, because we don't typically put justification in the ordinance, and as was mentioned, it's not in the master plan, but there was no evidence presented in any of the court hearings about the benefits of trees, or that it wasn't,
Yeah.
or it shouldn't be characterized as a mitigation. That's just stunning to me.
Yeah, I don't know, honestly, if there was, I wasn't involved at the trial court
Yeah,
level, so
no,
I don't know what was actually put in front of the trial courts.
Yeah.
But, so it could be that there was evidence put on trial that the appellate courts just chose not to look at. So I
Okay.
don't know what was exactly going on there, but I think, honestly, I think what was going on, again, go back, this is a novel application of a doctrine that hadn't been applied before. And there's a general consensus that trees are important and it's not unreasonable for governments to protect them. I think everybody was just thinking, well, yeah, trees are important. If you cut them out, we should have, it's not unreasonable to ask you to replant them. What's the big deal? And the courts didn't go there. They looked at the numbers, $446,000 in assessment fees set against what they paid for it, and said something's wrong here. And they looked for a legal doctrine to get them there. And this doctrine, this unconditional conditions doctrine that they honed in on, requires some demonstration by the government that there's rough proportionality. That was a novel application. Let me say that again. They didn't. Your lawyers didn't see this coming because it hadn't happened before. There's no case law out there to suggest that they were going to lose, right? This was a novel application, so I think it just caught everybody. My take on it is, it just caught everybody by surprise. Whoa, here's a novel application. We didn't think it was going to go anywhere, but the courts bit. And private property rights, we're going to defend them. The courts see themselves as protectors of private property rights. That's not an unreasonable thing for the courts to be worried about. So we're now in a world with climate change and trees and environmental protection. You're going to be better off doing the background work to really justify what you're doing, because you're going to get skeptical courts who don't see why you're doing is reasonable, what you're doing is reasonable. That's kind of where this is coming from. I don't want to make it sound like I'm shooting at your legal counsel,
No,
like they totally dropped the ball.
I was just surprised to
Yeah.
read this. Thank you.
So whatever the reason was, this is where the Court of Appeals landed, both of them. We just don't see any evidence that this kind of assessment was done. How can you justify it if you didn't even do an analysis? That's where they landed. So it clearly, it didn't pass the test. Yes.
And even based on this, our previous legal team, they wanted to go to the Supreme Court with us, and this would have fallen flat on its face, plus cost the township
It
millions.
would have, though there is, on this question of should this doctrine even have applied, they might have actually, there's some credible arguments. There was just another Supreme Court case just came down, another one of these unconstitutional condition claims, and Justice Sotomayor was, I think it was a unanimous decision or close to a unanimous decision, including the liberal justices on the court. They don't always agree on everything. They all agreed that unconstitutional conditions doctrine was apt in that decision. But Justice Sotomayor pointed out in a concurring decision, hey, wait a minute, nobody's asking the preliminary question, does it even apply in this case? I think there would be a credible argument in front of our U.S. Supreme Court that this shouldn't have applied. But knowing the composition of the court, I'm not sure she would have prevailed. So I
that's
think it
fine.
was actually prudent of you, was it? Or not
Oh,
your
that's
legal
actually-
counsel, but I think it was probably prudent
That's
of
why
you
the
to
board
not
said
keep
no,
going.
because
Yeah.
of the composition of the court, and also costing them millions of dollars to do
Yeah,
so.
the money that you spent on it, yeah. So better, frankly, to be where you are now and trying to figure out how to do it right
Right.
and become the model for everybody else to follow. You kind of took your lumps, but you're going to become the model for everybody else to follow. Yes, sir.
We always are.
So the conclusion is township lost, right?
You lost, yes,
Yes. So now we're trying to make sure that we don't
exactly.
lose. That's
Yeah.
good. That's all I need.
Yep, yep. Yes, sir.
So, let's say, for instance, a building department, there's a property, they start storing materials, that's against the use. There's a fine imposed on that property owner. Same way as you get a speeding ticket, you get a fine, $200. There's really no calculation for this fine in the same way. I mean, why does that have to be justified versus a fine, I guess?
Yeah, that's exactly was my concern. That's our big concern. They are stretching this doctrine now to apply. Usually when you issue a permit, it's just to make sure somebody's doing what they're supposed to do, right? And if there's any harm they're causing, that you're mitigating it. That shouldn't have tripped this special doctrine. That should really only apply if you're demanding somebody give up a title interest to their property, an easement or something. That's the scary thing about where the courts went here in applying this
Because
doctrine.
with the hypothetical he's giving,
Yep.
what Commissioner Cruz is talking about is something penal in nature as opposed to giving something up, taking somebody's right to their property or whatever. So I think that's,
Yeah, and your tree ordinance did not assess penal fees too, which made it easy for the courts to say this is an unconscionable taking. Yeah, and honestly, I'll point out, that your tree assessment fees, the court kind of said, well, this is stale information. Well, it probably actually worked in the property owner's favor because the tree planting fees you were charging were less than what it was probably costing to replant trees by that time. So the courts didn't even really understand the dynamic of tree mitigation. This is just not an area that many judges have spent much time thinking about. So there's a difference. So my concern is they're stretching this doctrine to apply in situations and forcing governments to defend their actions in a way that they haven't had to do before because of this slippery use of the term. But I'll come back again. You're regulating private property. You're hitting people with fees that can be pretty substantial. Even if not legally required, it's still good practice and policy, I think, to come up with good methods to make sure that what you're imposing are reasonable justifications. And if you can do that, you're also laying the groundwork to win a lawsuit if you get litigated again. I think that's the better way to think about what's going on here. These slides just kind of lay out, here's some things to do. The bottom line that I'm going to stress here, and then Jesse's going to pick up on it, is what I think you need to add to your ordinance, and I think where you're headed is for any time that you issue a permit and you require mitigation from a property owner, either leaving trees or replanting them or specially paying into a tree replanting fund, you need to do some individualized assessment demonstrating here's what these trees, here are the services these trees are providing and what we're losing because you're taking them, and here's why what we're requiring in the way mitigation is roughly proportional to that harm. The good news for you is there's lots and lots of research out there that's making it easier to provide that kind of justification. You just need to have that baked into your process, and then you need to have some kind of formal final determination by Zach, probably, or an arborist, a developer's arborist, saying, yep, this was a reasonable thing to do. The good news is I don't think you need to do that from scratch every time. I think you can have a whole lot of standard processes laid out and requirements established. You just need to make sure every time you tell someone you need to mitigate, somebody kind of steps back and says, is this a reasonable thing to do? And then provides us an explanation to the property owner. Here's what we're requiring, and here's why it's reasonable, and here's how it applies to you. if you had done that before, there's a much better chance that you would have won these lawsuits. Who knows? I'm flipping a coin. But you would have avoided the conclusion that you weren't providing any justification for your mitigation requirements. So given that, what we did through the class project that we convened was, okay, what would a community do to provide the background studies and the research and to document why trees are important and how you could protect them, and to develop this process that you're now working on to bake into your master planning and ordinance efforts. And so Jesse's going to go through what our student project came up. Any other questions? Yes, ma'am.
Well, my question is kind of a step further, and Patrick and I talked about it at one of the planning meetings. We have developers that come in, they want to cut down a bunch of trees, develop something. We say, okay, but we want you to plant some trees. They say, yep, we'd love to. That's a great idea. And then they don't end up doing anything after they tore the trees down because their development stops, they run out of money, variety of things happen. And so, Patrick, I think you had mentioned that there was going to be some sort of way to assess them if they end up not doing that, and I'm assuming that has to be a part of this ordinance. And does that feel like something we could legally do?
In some of those cases, one in particular where it's a plan development, so we have into the plan development agreement some of the modifications from the zoning ordinance they're obtaining and some of the definite benefits that they're providing. And in many of our plan developments, we note that compliance with the mathematical calculations of the tree ordinance can be a definite benefit to a plan development. So in most cases, developers that come before the Planning Commission will voluntarily comply with the tree ordinance and the mathematical calculation. One of the major reasons is it's a very predictable formula that they can pencil in at the outset of their project, so it's very predictable. It's something they can budget. And in cases like in one of the projects where it's on pause, but they haven't withdrawn, I think they're probably going to regroup and revise their application, and they'll be back before the Planning Commission. They've submitted a bond. A cash bond for replanting in accordance with the tree ordinance. And they've obtained the tree permit to do that preliminary clearing, and we've held the bond. So basically, we'll keep that bond until they replant the trees, and then if for some reason the trees don't get replanted, we would either use the bond for planting trees elsewhere in the community, or we may otherwise negotiate it with them.
I think that's, so speaking generally, not about the particulars of your ordinance, the Michigan Zoning Enabling Act allows for requiring performance bonds to make sure that developers follow through with what they're supposed to do. And if your initial requirements are reasonable, they're doing harm, they're taking out trees, and that passes muster, it's entirely reasonable to say, and we're going to hold you to it. And if you don't, maybe you didn't do your development, but you took out all the trees, and you need to mitigate and hold them to that. The trick there, I think, is frankly just more administrative. You need to make sure you have the staff capacity to monitor what they're doing and be ready to call them on it. So I hear a lot of communities that make requirements and they never follow up. So if you're going to require that the trees survive for 3 years, make sure you're getting staff out there to check on the trees and kind of hold them to it. 2 or 3 years is what you need to get a tree established. So that's not so much a legal problem, it's more just make sure you design the ordinance in a way and provide the staff capacity to provide for that follow through.
Sorry, I was looking at the page on legal defense for the individualized assessment, and I was just wondering about where it says document property values before and after tree removal, including timber values. And I'm just wondering, I understand including timber values, but trees are valuable not just for their timber. So I'm wondering, can we include something else about the value of a tree?
Yeah, so there are lots of good reasons to protect trees. There are a lot of efforts right now to put monetary values on trees. The iTree programs, because they provide really good stormwater service. Jesse's going to talk a little bit about this. In a way, that's good, right? That gives courts numbers they can work with. In a way, it's bad, because now we're turning everything into dollars. And that can be a trap if you've got good justifications for protecting trees that it's really hard to economically value that. But there's room to head there. The reason I put that in there in particular, I think the courts just assumed in this case, because you're assessing fees that are more than what the property owner paid for the property, that you took all of the value of the property. That was a factually contestable assertion, right? That property still has value. In a way, maybe it has more value because it's been cleared and it's ready for development. People pay money to grub sites and clean them off. And that can cost them a whole lot of money, and then they end up with a piece of property that's actually on the real estate market more valuable. So that would have, if that kind of assessment had been put in front of the court, it would have kind of punctured the balloon that you clearly took all of the value of the property. I think that was a contestable case. Again, I don't know, maybe your lawyers put that in evidence and the courts just didn't pick up on it, I don't know. But it didn't make its way to the Court of Appeals.
I've seen that there are some communities that inventory all of their trees and attach a value to every tree, whether it's, what it helps with climate, what it helps with stormwater mitigation, what it's added to the property. But I don't imagine that very many communities are doing that with every single one of the trees in their community.
There are groups out there that are developing new technologies to do that kind of inventory. I'm going to let Jess.
Okay.
Any more on the legal stuff? Or do you all, okay, take it away, Jess.
Trustee, we actually did that a bit with some of the trees we planted this year as part of our grant for the park. So we went through and we calculated using iTrees the value in carbon dioxide removed, ozone removed, stormwater abated, all those types of things. So it is possible. It just takes some efforts.
Thank you.
Awesome. Well, thank you so much for having us tonight. My name is Jessie Williams. I am a third-year incoming law student and urban planning student at the University of Michigan with an interest in land use law specifically. So this has been really, really an exciting project to get to work with you all on. And so thank you so much for allowing our student group to do that. So the next kind of section of our presentation, titled Designing a Strong Urban Forestry Program, is looking at beyond solely the ordinance, because we know that master planning as well goes into informing land use policy and supporting land use policy upon challenge at times. So overall, our purpose of why we are here is to promote and eventually help Canton Township develop effective and legally defensible local master plans, urban forestry master plans, and ordinances to show the interest and the reasonableness and the value in tree protection in response to litigation, then also just in general moving forward. So the two main components that I'll be kind of going over in this section are general guidance and context about urban forestry master plans, as well as zoning ordinances, as well as the application to Canton Township directly. Some of those issues that Professor Norton discussed, both about like evaluating the value of trees specifically, as well as that distribution of burden between different property owners with different sized parcels and everything. So we'll be chatting about both of those. And similarly, if at any point anyone has any questions, totally feel free to raise your hand, and I'm happy to answer to the best of my ability. So just kind of some guiding questions for our discussion for Canton Township's subsequent policy discussions is, firstly, the set of broader goals the community is attempting to advance with tree preservation and with these mitigation requirements within the community. Secondly, talking about how much of the community should be subject to regulation to further those ends desired by Canton Township. If, for example, residential to a certain degree should be exempt for individual property owners. Third, the kind of mitigation that the township is looking to require. Do we want to prioritize the mitigation of existing trees, or preventing the loss of existing trees, requiring restoration of trees from the past, prioritizing off-site planting in certain areas? Those are all policy determinations to be thought of in tandem with these constitutionality considerations. Fourth, like mentioned, preventing the loss of existing trees versus if we want to allow development so long as any loss of trees is mitigated by planting off-site. There's different amounts of value placed on the value of an existing tree in terms of ecosystem services versus new planting trees elsewhere, but different communities treat that differently, and so ultimately that's policy determination. And then lastly, if trees are removed, what should be the appropriate replanting mitigation within the township? Everything. Conversation will just provide a couple of options about that. So a little roadmap in terms of where we're going for the remainder of this discussion. Firstly, the state of urban forest master planning, which is something that is really valuable for communities that are considering making tree preservation a more predominant part of their ordinance. Within that community engagement, considering different stakeholders, considering those stakeholders' needs and desires in terms of tree preservation, that goes in tandem with justification. Strategies for implementation, loss mitigation, again, those kind of desired forms of mitigation, whether we want off-site, whether we want on-site mitigation, whether we want to prioritize keeping those existing trees, or whether repayment for equivalent is okay. And then next, talking about justifications, as we mentioned, within the ordinance, within the plan itself for why trees are important in our community, public health, economic justifications, land value justifications, ecosystem services, aesthetics, like these are all considerations to be incorporated in both the master plan and the zoning ordinance. And then lastly, just kind of where we are, where we're going in terms of the master plan and everything. So kind of looking at the three different phases here. Firstly, the master plan, the urban forestry master plan, is something that shows that the community has provided a great deal of value to tree preservation. This is a high priority for the community. It justifies that in terms of backing up whatever zoning ordinance changes the township aims to develop. Next, looking at that kind of standardized but also individualized site assessment, mitigation determination and plan, as well as the ordinance provisions justifying mitigation. So starting off with the urban forestry master plan, kind of that planning-based background for why communities find trees to be important and want to continue prioritizing them. So firstly, we wanted to address climate change impacts from both the mitigation standpoint, helping to prevent climate change impacts through carbon sequestration, through other beneficial ecosystem services, as well as adaptation, that by tree cover, by this increased canopy, you're able to adapt to the effects of climate change through decreased heat, through shading and other effects, stormwater mitigation as we see increased flooding. Next, talking about general ecosystem health and how tree preservation can go towards those ends. Species diversity in terms of protecting the existing variety we have, which is important if any one species was to fall victim to any kind of disease, for instance. Protecting wildlife corridors and the animals that keep those trees as their habitat, as well as having this balance between invasive and native species of trees for what is most prominent growing in the community. Next, in a lot of successful urban forestry master plans, you'll see this is Columbus's urban forestry master plan here. We see data-driven justifications for why they are planning and subsequently regulating the way they are. As we talked about in terms of evidence for a zoning ordinance, it's important to provide that justification and insight into the motivations of the government in adopting these tree preservation strategies in the first place, as well as how is the government's particular preservation strategy going to be helpful in mitigating those harms that they're trying to accomplish in the first place. And then additionally, just general planning good practices, emphasizing community engagement rather than top-down planning, having these discussions in the community about these issues, about tree preservations, talking to individuals with different interests, whether that's developers, whether that's individuals who have trees, preservation-oriented folks, having this deliberate effort to hear from the community in the formation of policy, both from the master plan and the zoning ordinance. And then lastly, talking about promoting equity in the community, we see generally there are gaps in access to green space, to canopy cover from trees in general. Urban trees within more urbanized environment, it typically follows, unfortunately, that there's a decreased amount of green space and canopy cover from trees, which can be one of the factors contributing to urban heat island effect, tons of negative public health impacts from that. So by adopting ordinances and master plans that are promoting tree preservation, we are helping to mitigate those impacts. So as we talk about mitigation strategy, Professor Norton got a little bit into this, but there are different options that my team was looking particularly into what different ordinances across the state were doing that we saw across communities. Firstly, prioritizing preservation of existing trees. This is typically viewed as like the gold standard, like if we're able to adopt site plans that are decreasing the amount of trees taken in the first place, this decreases the need for a lot of this mitigation in the first place. So that can be very helpful in having those conversations with developers from that. Secondly, replanting on site helps to mitigate that immediate harm to that particular parcel. Replanting off-site still has that impact in the community and everything still directly proportional to what is what trees have been taken from the site just in a different location. A lot of times this ends up being on municipal land, for example, in park spaces, paying for the replanting in those places. And then lastly, the payment into a fund with clearly justified basis for those fees being assessed. We also talked about how canopy cover is viewed in mitigation strategy. So beyond just looking at individual trees and their value, how do we look at stands of trees when they're grouped together, the impact that they have? Canopy cover is typically viewed as a good thing for communities. In different communities in Michigan specifically set their goals for canopy cover differently. We see this both in the master plans for communities as well as in the zoning ordinances. And as a reminder, when we're looking at things in the master plan, that's guiding land use policy but isn't enforceable against individuals per se, whereas when we're putting things into the zoning ordinance within districts, that is enforceable for maintaining those goals and everything. So communities do that differently. Some just want to prioritize, like, okay, residential areas, we want to have this proportion of canopy cover, or even a citywide goal, for instance. City of Grand Rapids has that. Zoning district, right in the ordinance, having that more enforceability can apply to particular parcels. Like if this is an R2 zoned parcel, this needs to have 30% canopy cover or particular mitigation to require that. So next, as mentioned, we talked about the mitigation plan and determination, which gets right to the heart of what Professor Norton was talking about in terms of justifying the mitigation requirements that are being imposed from the township's end onto particular property owners. Firstly, we're looking at that individualized site-specific determination as discussed in the court case, applying the ordinance's general principles, procedures, things that the planning department has laid out in advance to that particular property itself, showing not just that you're performing the assessment for the administration of permits, but that you're showing that the mitigation you're requiring is helping mitigate the harm that's being caused by the applicant's actions. Secondly, from that, developing a mitigation plan, working with the applicant based on the information gathered to form that plan. And then thirdly, the planning department's issuance of a determination with findings of fact based on that mitigation plan that those harms are going to be mitigated by the actions taken, as well as kind of laying out that proportionality basis, that here's what's being caused in terms of harm, here's what we're requiring, and how that is roughly proportional. Just going back to that regulatory takings analysis, just ensuring this whole process is reasonable to ensure reasonableness and rough proportionality, that it bears the essential nexus, that these conditions are relevant to what's being considered. That's from Nolan portion. The mitigation must be related to the harm being caused, as well as the rough proportionality. It has to not be more burdensome than the harm that's being caused in the first place. This generally informs the appropriateness of the process, that as long as those principles are being kept in mind in ordinance formation and administration. So standard steps for imposing mitigating requirements as we're working with applicants, these are just kind of general guiding principles. Firstly, having really clear specification of the information that's required from the applicant in the first place, ensuring that the ordinance is something that's helpful to work under, as well as having wonderful discussions with staff about those questions. Clearly conveying what's expected of them in terms of prior analysis, any assessments that they might be expected to do, or any assessments that the township might be doing. Next, identifying the means for mitigating tree removal and having this kind of clearly established menu kind of basis of what has been done in the past, menu of options as applied individually to the site or the type desired by the applicant. Again, with that foundation of showing what harm is being mitigated and how these particular requirements are solving it. Nextly, deploying those appropriate methods that the ordinance and master plan together will help to work out in advance. So setting these in advance and clearly laying out in the ordinance to meet the applicant's expectations. As well as the appropriate replanting standards are also included in that. That goes in tandem with, as we were talking about, the kind of accountability factor after the fact. If we're requiring in the ordinance that these trees still be alive 2 years into the future, that they've been taken care of to such an extent that that's possible, including those standards in there as well too, so that any cost that goes into effect with mitigation ends up being worthwhile in getting the community that kind of tree canopy that's desired in the first place. And then lastly, identifying considerations for adjustments. So one thing that's always neat about working in land use is that each parcel is different, has different considerations, soil types, topography, and everything. So each case, and that goes right into our site-specific assessment. The site-specific assessment allows the room for reasonable flexibility within the bounds of the ordinance to continue meeting the intent and requirements of the ordinance, but it benefits both the applicant and the township in being able to work together for a solution for this particular site and everything. So that's one thing that we found to be important. So as we look into mitigation principles in general, firstly, minimizing impacts. Again, the best kind of mitigation is the one that's not needed at all. So if we're minimizing impacts in the first place, that limits the amount and subsequently the cost of mitigation that applicants are going to be doing. By removing only as necessary, potentially building and developing around stands of trees to the extent possible. Secondly, when we were looking at approaches, besides just keeping trees in place in the first place, there's also replanting on-site, replanting off-site, or the imposition of reasonable, widely justified fees. As we look at the different approaches in terms of what ordinances have required, what we can see in terms of proportionality, this kind of rough diagram here shows the X to X is like tree to tree. This is what we're seeing a lot of communities do across Michigan generally, just the tree to tree mitigation and everything. We're also seeing the inch to inch in terms of caliber. So when we're looking at the age of trees, the health of trees, obviously larger trees are going to be performing more ecosystem services. So some communities have required that, for example, if you have a tree that's 6 inches in diameter and you're planting 2 3-inch trees to mitigate that. Similarly, we have the Y times X, this kind of idea that you must plant a certain number of new growth trees per each old growth tree taken. So those are kind of different approaches, again, all justified with the ordinance. Yeah, you bet.
Yes, sorry. I'm going to ask this question. Unfortunately, I actually have to leave, so I didn't want to get too far. But this sounds a lot like what we are doing today in terms of determining the standards of what we would replace. And perhaps, Professor, I should have asked it when you were presenting. But since the court specifically talked about the cost of mitigating the trees against the cost of the property, do you think we have to take that into account when we're creating the ordinance, like some limit that we won't go above 10% of the cost of the property? I think it's the button up here under the green, yeah, so.
Yeah, they didn't, so I pointed out that this, what you were assessing versus the cost, that actually was mentioned in the facts, but the courts didn't hone in on that in their analysis. It just looked like that was the thing that was getting under their skin. So coming back to the earlier question, do we have to document the dollar value of all of these trees and kind of show a benefit-cost ratio? The court in the Dolan case that established the rough proportionality test made clear it doesn't need to be mathematically precise. It doesn't have to be perfect proportionality or precise proportionality. It only needs to be roughly proportional. So to the extent that you can document, there are lots of reasons to have trees, and the mitigation we're requiring is proportional, and some of that might be dollar values, but there might be other good justifications. That'll give you what you need. So I wouldn't say that you need to always boil it down to a hard dollar value about what you're requiring versus what the property value is.
But should it be a part of it? Or should it be not in there at all? Or is it still up for discussion?
Yeah, I don't know. I don't even know what you guys are thinking about in the draft that you've worked up.
Yeah, on the draft, and still a work in progress, but we did add a subsection with all the different mitigation options that we have. One of those options is payment into the tree fund. And in one of the subsections under the payment into the tree fund option, we have that there is a maximum payment based on a percentage of the land value according to the Canton Township assessor.
Okay.
So the first number we started with was 50% of the land value. That could go up or down if we keep it there, but that's one of the things that we had flagged for our council to look at in terms of proportionality and,
Okay, good.
Yeah, I'm not sure that you have to do that, but that might be good practice. just
Honestly, I
extra
don't trust the
protection.
courts not to make it an issue if we didn't have it in there, so
Yeah.
I'm probably
It's
fine
probably
with
something
having it
worth
in there.
contemplating as you administer your ordinance, yeah.
Okay, and I apologize, I have to go. A
Yeah.
couple of us have another event that we have to attend, but
Oh, yeah.
I will watch the rest of it on video, and thanks for your input.
Having us. Yeah, so just continuing on as we talk about the mitigation and justification process for the mitigation requirements, again, this is kind of uncharted territory. So we're kind of looking to jurisdictions that have these more extensive tree protection plans as well as just general arboriculture best practices. So as we're looking in the future to who will be doing this kind of site-specific determination for the appropriate mitigation under the tree ordinance as updated, we look at the options to have a local government arborist on your staff do this, or have the applicant select an arborist of their own choosing, or to have a non-arborist government employee. And this, the options kind of depend on the degree of difficulty or the degree of complexity of tree removal. Some jurisdictions, such as the city of Westland, have an option that when it's kind of, as we were talking about the exempt properties, if it's a property owner on a residential parcel who has one tree that they're desiring to take down or something, having these less complex cases go through government employees as defined in the ordinance, specifically delegating them that authority. But contrastingly, if we have these large developments that are going to be taking a large number of trees, potentially landmark trees, having that arborist to determine the level of harm that needs to be mitigated and needs to be compensated for in the mitigation requirements. Similarly, as we were talking about the assessed value of trees and how we determine that, obviously, as Professor Norton was discussing, it can be difficult and sometimes not even necessarily the best practice to delegate everything to a dollar amount. But that is unfortunately the way a lot of things are determined for compensation. So we have tools like iTree and MyTree that can give the value essentially of what these ecosystem services are doing to be compensated for. iTree landscape, it's difficult to determine though, however, how these tools might necessarily hold up in court. Even though their scientific methodology is based on best practices and everything, it is still an estimate to some degree. Additionally, so iTree Landscape is one tool that you can look at through the web. It tends to value larger intact woodlands higher over smaller parcels, which can potentially contribute to further inequities in terms of where trees are currently placed versus where they are currently sparse. MyTree is similar in terms of looking at individual trees. It's a more complex process, but can get you some of those detailed metrics as well too.
Jesse, can I just comment? When we started this, I knew there were these programs out there that people, the Forest Service and others have been developing. I'm thinking maybe it can all be computerized now and it'll be really easy. And we test drove some analyses, and it turns out it's really still not that easy. You still need to have an arborist who understands the process to put the values in to do the assessment. So those are tools that are out there that will be helpful, but they're not going to replace having trained staff and arborists kind of doing some of the baseline calculations for you.
For sure, for sure. As well as, sorry, I totally went out of order here, but scientifically rigorous random sample, whether this is by the arborist or for those smaller amounts looking at government employee, if that's a desired action as well too. Depending on capacity, taking a scientifically rigorous random sample and valuing those ecosystem services of those trees can prove important too to mitigation. So as we're determining both mitigation in general, just in terms of what would be required in a site plan, as well as these kind of site-specific on-site planting, off-site planting versus repayment, some factors to consider include woodland conservation in general, these larger stands of trees that have increased canopy cover that we're looking to prioritize, stormwater management in general, just because so many trees end up having these ecosystem services in terms of absorption, of runoff and everything. The kind of payment, again, whether that should be direct replanting or whether that should be proportional and justified repayment into a tree fund. Wildlife within the woodland area, if this is known to be a particularly sensitive wildlife corridor. The health and vigor of the tree stand. So this is something we encountered in a lot of ordinances, that if trees are diseased or dying, they might be valued at a lesser extent. And in some cases, when we were talking about the I tree and my tree, placing a monetary value on the amount of trees can even be considered more of a liability than an asset. So viewing sick trees, unfortunately, differently than healthy trees, that might prove to be a financial asset to the community. Looking at tree species, whether there's diversity in what's being kept, what's being proposed to be replanted and everything. Soil quality, the type of soil, and whether that's conducive to the type of species that are being able to be replanted here, and habitat quality as a result. And again, kind of as discussed, this will be something that as the township kind of goes along, starts doing these mitigation plans and approaches, and then findings of fact that this is a proportional mitigation, this can kind of get more intuitive as it goes and everything. As mentioned, stormwater management, canopy cover. Yes, perfect. And then, so determination is something that's kind of been mentioned throughout. This is just kind of the government's final sign-off, this arm's length review of mitigation to ensure that it's reasonable, roughly proportional. The establishment of these findings of fact that are coming from the planning department, showing that the harm that's being caused by the applicant's actions, potentially taking of trees, is being mitigated, and how so by this, by the required results of the tree mitigation process. Again, taking into account those considerations prior of mitigation generally and everything. So existing tree ordinance practices, this was kind of what my group took a look at primarily. Again, just the view of Canton Township not being an abnormal tree ordinance in the first place. We're seeing a lot of places across the state do similar things currently. Generally, what we're seeing is that most jurisdictions similarly required permits prior to taking trees when not covered by an exemption. So different communities defined exempt trees differently, whether that was on a residential parcel, like with Canton Township's under 2 acres requirement and everything, whether that was trees that were under a certain caliber, so they were too young, too immature to be providing substantial ecosystem services as viewed by the government at that point, or as mentioned, whether trees were diseased or dying at that point. Next, looking at the assessment method, the majority of municipalities that required this required a base level tree survey to be submitted to the community planner, showing the trees that were currently on site and the trees that were to be kept and or replanted afterwards. Next, talking about mitigation, most had that ratio basis, that either 1-to-1 or 3-to-1 determination that we were talking about earlier. That particularly came into play when we were talking about landmark trees, which each community defined differently, and Canton Township does as well. Looking at these trees that have more ecosystem service value because they're larger, because they've been in place for longer and perform more services for the community. We also saw some communities, such as Ann Arbor is mentioned, that has the diameter-based mitigation instead. Next, talking about, as mentioned, the exempt removal not requiring a permit tended to be the term we went with for that. That was fairly standard across local governments, that at least some trees were determined to not require a permit from those standards. So that could be trees under a certain diameter, emergency situations or hazards, either as determined by the property owner or as determined by the government. Sometimes that included communication with the government after the fact, like, hey, I had to take this tree for this particular reason, and trees that are diseased or dying. And then lastly, communities that had different definitions, for example, of landmark tree or ordinance-specific terms that they were using, either that or more highly technical terms that individuals might not be familiar with generally from looking at a zoning ordinance, had those terms defined in the community or in the zoning ordinance for that particular community. That can also come into play if they're using a term with a debatable meaning or something that might mean different things in different circumstances, or an acronym like DBH. So as we look at Canton Township in particular, here were some of the graphs that Professor Norton was mentioning prior when we're talking about the distribution of regulation within the community and everything. As we've discussed prior, we currently have the permitting threshold at 2 acres. So property owners who own less than 2 acres in that particular parcel do not have to receive that same level of permitting. So here we see on this graph the number of tax parcels greater than or less than 2 acres in area. You can see the x-axis on the bottom is showing parcel area, and you can see a pretty dramatic drop-off from the under 2 acres. So we're seeing that above 2 acres is actually only 4.5% of total tax parcels within the township. So a very small proportion of parcels compared to the majority, the vast majority, that are not subject to that regulation. However, within those 4.5% of tax parcels, because they're those larger parcels, they still cover 62.3% of the total parcel area in the township and everything. So that surface area is still getting covered to that point, even though it is a smaller, vastly smaller number of parcels that are being regulated themselves. So again, this is a separate graph discussing the tree canopy cover in general within the township. We see generally a large skew to the left that we're seeing low canopy cover percentage by parcel. We're seeing this median at 11.4%, and a lot that currently do not have tree canopy cover, as mentioned, when we look at the frequency. Any questions on either of the graphs? I don't want to skip by these. Yeah. Yes, no, for sure.
I just needed to explain just a little bit. You're saying, if I'm understanding, tree canopy covers per tax parcel?
Yes. 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 Do we want to take a look at the
Say it
first?
one other way.
Yes. So if we
I
want
don't
to
know.
go back to the first graph, maybe, or the second one.
I think I understand the first one.
Okay, perfect. No, that works
one
great.
is throwing me.
This is just kind of showing that the vast majority of Canton Township tax parcels, as shown by the vertical bars, have a low degree of canopy coverage. We're seeing more of that
Got it.
concentrated at the left end here.
That
So
helps.
yes. So currently, there's already a degree of low canopy cover in general by frequency of parcels. Was that helpful at all? Okay, perfect. No, please, if there's anything that I can rephrase better, please.
Why this is useful is there are communities that have a target for tree canopy, maybe by residential areas, we want to have 40% canopy cover, or commercial, we want to have whatever percent, or just overall, we want to have this. So it could be a potential gateway of if your canopy is already above that, then maybe you're exempt, or the mitigation's a little bit different, and maybe if you're underneath that, it's a bit higher.
For you, Zach. So are we thinking something along the zoning lines, like, R2, R3? Is that something like you would consider, like?
We haven't got there yet, but we wanted to present this to see if it's something you wanted us to investigate.
There are communities that distinguish between industrial and residential and commercial, and they have different target tree canopies for those different land uses. Your zoning ordinance currently doesn't make that distinction, but some communities have gone there. So that's something to think about.
So right now it's 2 acres regardless of zoning, is that correct? Do we know what the rationale was when they came up with the 2-acre threshold?
People are with us, and that's why we don't.
Okay, I was just wondering.
I think the one rationale I was given was Mr. Snyderman, I think, was that we already got them when they subdivided and created all of these small lots, and we regulated them on their trees then, and we're not going to do it again for these small lots. But you've got a large number of small lots that, well, I think the next slide actually is going to speak to that. This one takes a little bit of explanation too.
Yes, no, so for sure. So these 3 separate graphs that we're taking a look at, this is kind of an experiment for the township if they were to regulate a different size parcel as the minimum size threshold parcel for being subject to the tree ordinance. So you can see the x-axes along all 3 graphs, which will differentiate, are increasing the threshold of what would be subject to the tree ordinance. So as we look down at the figures at the bottom, when x equals 2 acres, the number by x meaning the threshold of parcels regulated, we're seeing that 5% of parcels, and that's by number, so number of parcels within Canton Township as a whole, 5% of those parcels are subject to this, 4.5 technically. But that comprises 63% of the parcel area within the township. So 63% of the area in the township is subject to this ordinance. And that comprises 71% of the total tree canopy within the township is subject to the ordinance, as it currently stands with X at 2 acres. When we decrease X, for instance, to 0.25 acres, so a quarter of an acre, again, this was just one of the numbers that our team picked. 38% of parcels by number of individual parcels within the township would be subject to the ordinance. That constitutes 85% of the total parcel land area within the township would be under the ordinance and subject to those mitigation requirements. And that constitutes 90% of the tree canopy within the township totally. So when X equals 0.25 acres and up to quarter acre parcels are subject to the tree ordinance, that increases from 71 to 90% the percent of tree canopy that is covered under the zoning ordinance. Yes. Yes, you bet. Yes. So that would be up to the township's policy determination. Yeah. Yeah.
Anybody with a quarter acre lot or larger would now be subject to it, having to get a permit. Well, can I?
Yep, go for
Can
it.
I cut in? So that's now the policy, some of the policy choices you need to make. Are you just going to require that they replace trees that have been lost, or do you try and get more trees back into the system? And that's a choice for you all to make. It doesn't have to, there's no fixed answer to that question. It's really where does the community want to go in terms of how it's trying to increase its tree canopy? Yep, yep.
Right.
Yep. Well, if you go down to a quarter acre lot, now, instead of only 5% of your property owners being subject to the permit, 38% would be. So there are a lot more being hit, but still quite a bit less than half the population that's going to be subject to this regulation. I mean, what the curves allow you to do is kind of figure out where's the sweet spot. That has the benefit, right now, this was my concern when I first saw this litigation. You have a regulation that only applies to 5% of your property owners. That's a pretty focused burden to put on a very small number of property owners in the community, right? You're only subjecting 5% of your property owners to this tree permitting requirement. I don't know, and maybe that's fine, because you're also capturing more than half of the parcel area and almost 3/4 of the canopy area, right? Maybe that's a good trade-off. And it is the case, it's the case, you buy property, you know what's on it, you know it's got conditions. Just because my neighbor didn't have to get a tree permit because they've got a much smaller lot doesn't mean I'm automatically exempt from that requirement. The more that you reduce the parcel size and the more people you capture, the more you're starting to spread out that burden. But when does that become too painful or unfair? That's the policy choice that the community needs to figure out. There are some communities that apply their tree protection ordinances to everybody. That's zero. That's this parcel size of 0, right? Everybody has to get a permit, or they pick a threshold. So what we tried to do in these graphs was just to show you that given the distribution of how your property has been platted in this township and where the current trees are, where you set the threshold is going to affect different numbers of property owners, and it's going to capture different quantities of land area. And I don't mean to suggest to you that you should give up you could decide it still makes sense to keep it at 2 acres, and that's fine. You'll just want to, what you just said, you just want to be able to justify why this is a reasonable place to draw that threshold.
So it's going to have to be a balance in many ways, I think, not just, thinking about the burden on homeowners, but also the burden on the township, because we'll be using more staff and more time.
Yep. So that's my big concern through this whole process. I understand the policies and why this is important and why this needs to be considered, and I'm all for putting in the appropriate ordinance, but I do get concerned that we make the process too burdensome from an administrative standpoint and too bureaucratic. It already takes a long time to get a development proposal through a governmental process, and I'm not just talking about Canton, I'm talking about a lot of places. And what the steps we're talking about taking here could be time consuming, especially given that, depending upon the time of year you come in with a project here in Michigan. So there's that issue. The other thing I hear is, and Patrick, refresh my memory, how many, did you say that the draft ordinance you have, did you say first 6 pages or first 6 paragraphs?
6 pages.
I think that's ridiculous, quite honestly. I mean, I'm all about economic use of language. I can't imagine what is said in 6 pages that can't be said, I'll say even 2 pages from a policy perspective. And truthfully, just so you know, Professor, I'm an attorney, so I'll maybe you and I will argue about this, but when you talk about the preambles or whatever you talk about in an ordinance or a statute or something, those aren't law per se. All that is justifying the ordinance or the law itself. You can put what the justification is or something in another part. It's called legislative history a lot of times. So I'm just forewarning you now, Patrick, if you're coming to the planning commission with a minimum 6-page ordinance that doesn't have any requirements to it before I get through the first 6 pages, I'm going to have an issue with it. So I think there's a way we got to make sure that there is a balancing act, to use your word, Kate, that not only from a justification for needing these regulations, but how we administer them. And to your point too, there is a cost to the township for this. You're talking about adding another body to the township. I mean, we're always talking about paring down budgets and that sort of thing. So that's definitely a concern also. I mean, obviously outside consultants be brought in, but that's money as well. So there's lots of things to consider just beyond the making sure that we have trees adequately protected and not just wiped away throughout the township.
And speak to a couple of those points with the purpose and intent statements. Once we get to the ordinance review process with the planning commission, we'll kind of go through those, and they may be pared down. One of the reasons they're as long as they are is there's really not much in the master plan, so we're leaning more on our purpose and intent statements at this point. Where we can parse some of that more into the master plan, we'll definitely try. It's just a matter of what's going to be adopted first, the master plan or the tree ordinance. Another item with the ordinance that I wanted to bring up, and this was an idea that Zach had for the draft ordinance that he had put into the draft, was having this area in the middle where it's not necessarily exempt, but it doesn't necessarily require a permit. And that's an area of a list of activities that require approval by the planning division, where it can be informal, something like an email, or if it's a permit, something like a simple form where if there is tree removal within that, it's a very fast way to get approval. It's not a formal permit. And there are circumstances where minor tree removal could fit in that category, where somebody could get an expedited review. It could be either free or very cost effective, and it would be something that would be minimal staff resources in terms of staff review of it. So it may be something where someone gives us a picture of what they want to review, and then if we approve it through an email, we can upload that to the property database so that they can get a quick approval. So administratively on our end, that's something we're looking forward on in terms of how can we make the process easier. as one of the people that would ultimately administer it, that's one of the things front of mind for Zach as well. So we're kind of in a position where we're writing the ordinance, but we're also the ones that'll have to administer it. So sometimes people that write ordinances aren't the same ones that administer it, so you may get different ends of it. Because we're going to be having to administer it, we're thinking at it from the people that'll have to be working with our residents.
Yeah, I'm glad to hear that, Patrick. That sounds better than what I was imagining, knowing how sometimes it's quite burdensome to get a permit in Canton for various things. The other thing I think that needs to be part of the balancing act is also if mitigation is replanting, we need to consider the growing season and the planting season, because you don't want to be planting at a bad time of year.
I just want to ask for clarification on something. Commissioner Weber just said adding another staffer. And my understanding is that all of this would be done through current planning staff, right?
That's the intent. We haven't talked at all about any additional staffing. We're mostly looking at it as the current staffing of the planning division. How can we approach this? So in some ways, it's made us think more creatively in terms of how we can and deliver something to the residents while focusing more on those things that are important in terms of things that require a permit. And also trying to make them user-friendly. We're already starting to think ahead in terms of how our forms, administrative forms will look, how we'll administer that. So it's definitely something that we'll be sensitive to in terms of staff time, because with the staff that we have, we're looking at it in terms of how can we best administer this that's going to be fast and efficient for us, fast and efficient for the resident, and try to make it as painless as possible.
But,
Can I
go ahead.
add one? Just to, add to the point that both Kate and Doug brought up, as much that could be done from a staff level that doesn't have to come before the planning commission, I think would be great, not only for the folks developing property or homeowners, but also for the planning commission, just because of the volume of stuff that's coming before the commission. Just wanted to add that. Sorry, Doug.
No, you're right. You're absolutely right. Well, just the point, it's great if you can do it with existing staff, but we're talking about if you have people that are certified as arborists. I mean, if we're talking about having an actual arborist review it, whether it's a staff person or a outside consultant or whatever, that'll be dependent upon how you handle it. I mean, I'm just going by the recommendations that were being made on the board there, and great if you can handle it in-house without adding staff just for this purpose. But those are things that have to be considered as you go forward in adopting this policy.
Yeah, and speaking of consultants, when we do landscape inspections, some of those can be done in-house, but most of them for like commercial properties, industrial properties, site condos, we have a consulting company with landscape architects who are registered with the state that can go out and do landscape inspections, and those are pass-through costs where the developer submits a deposit and then the cost of those inspections are paid from that deposit. So it's a revenue neutral permitting or review and inspection process for the township, but it's in those cases where we need the expertise, where we don't necessarily hire a new employee who's a landscape architect. We use a firm. And with our tree program that Zach oversees, we have two of our tree contractors. They both have certified arborists on staff. So essentially, we do have some arborists under contract that we could use from day one. But as we move forward with the ordinance and we start to fine tune what requires a permit, what mitigation is, and how we look at what could be coming in versus what we see now. At that point, we could probably talk in more detail in terms of whether there's additional resources, whether it's staffing or consultants, and then how the workflow would go with permits. So as we get closer to that, we'll be able to give more answers in terms of how much staff time it would take.
Can I make just two observations real quick? One is, this is going to sound really bad, but in a way that is helpful to you all, it's a good thing that the township didn't do anything to justify what it did before in the court, or at least the court found you're providing no evidence of why your mitigation requirements are reasonable, because that sets the bar really low. You don't, remember, you don't only have to show rough proportionality, you need to make a reasonable determination. You don't have to necessarily do a scientific study. Probably don't need to have to do a scientific study for every mitigation. You've got a lot of room to figure out what's appropriate. So in a way, it was kind of good that the way the litigation played out in a perverse kind of way. So now just do a better job of justifying yourself. And then the second observation is, this is the planner and me. I always get this metaphor wrong. A penny saved is a pound earned. Is that right? All of the recommendations we're making aren't telling you, you need to do this. What we're trying to convey is, you should be thinking through all of these issues and then figure out what works for you. And a lot of what we're saying is good practice, I think, can fit comfortably with the staff as it currently exists. It's just how you package it so that if something gets litigated, or if a property owner is being told you need to do this, they understand why. You've laid it out on the table so that, okay, I get it. And if I'm unhappy about it, I'm going to litigate it. The evidence is now discoverable by the courts to see, okay, that you're being reasonable, even if the property owner is unhappy about it. So Mr. Weber, I think you're right. It doesn't all necessarily have to need to go in the ordinance. If you've got some place where you can see from the ordinance, this is what we're basing it on, and maybe that's the master plan or resolutions and such. So it's just, how do you package it? But you want to make sure at the end of the day it's discoverable.
Great, thank you.
Thank you.
I have a quick question for Patrick. Is that, as presented here, are you considering this 0.25 acre as a sweet spot, or are you still deliberating?
That's just an example.
That's what I thought, yeah.
Yeah, that's a really good question. And as part of the student project, we were glad that they did an analysis like this, where they picked a lot size and then they did a deep analysis in terms of what the impact is if we change it. So we could, with this methodology, we could always go back and adjust the lot size and see exactly what the impact is through our analysis. So this gives us a guideline for that. One of the things that we put into the draft ordinance that we purposely left blank was, in terms of trees that don't require tree removal, that doesn't require a permit, we had a blank number of trees per parcel in a given year, where regardless of how we land on the lot size, we wanted to put that in the ordinance so that we could have future discussions, so that if we did, let's say it was 0.25 acres, in that subsection, we could look at it and say, okay, do we want to allow any property in the township to remove a certain number of trees per year? Let's say it's 2 trees per year. So if someone's on a subdivision lot, they have a couple trees they want to remove, they may be able to do that without a permit if they notify us first, and it's in a given year. Or if there's someone who lives out in a more rural area on 5 acres, and they want to cut down a couple of trees each year for whether they make lumber or cutting firewood, that provision in the ordinance would allow us to fine tune that. That would allow for some removal with prior notice so that we can still track it, but it might not necessarily need a full-fledged permit. So we're looking for some of those gray areas where we can work and try to apply. If we lower the acreage threshold, we can do that a little bit more comfortably if we have a certain number of trees that each parcel owner could remove per year.
Now, I also have the question about, the natural calamities with our tornadoes that went past, and people had trees that were removed by nature. Like, do you put that in the ordinance? I'm just wondering how that works.
We did have that as one of the exemptions. So if it's an emergency, and we did have a lot of phone calls in the wake of the tornado last August and the storms that were back to back, and people asking us, we have to remove the tree, do we need a permit? So we did field a lot of calls, and a lot of them were subdivision lots where they had to remove it, but they did check with us first, and most of them were exempt. If it was an otherwise regulated lot over 2 acres, if it was something that was naturally occurring like storm damage, we consider that to be exempt. And we have some explicit language in the ordinance that does that. So if someone wants to see exactly where it's exempt, we spend a lot of time going through those exercises and doing that. In some cases where if there's a developed commercial site with a site plan and they lost trees as part of the storm, if there's requirements on their landscape plan for them to have trees, that is something that they would have to replant. Whether it was a storm or natural death of the tree, they would have to replant that tree. But in the case of the storm, some have replanted, some maybe not yet. And occasionally when we do site inspections, we look at the old landscape plan to catch up on that as a matter of just administering their previously approved landscape plan. So with storm damage, there's a lot of different levels, but a lot of it is exempt where there's not a permit.
I do like the idea of Al Roker having to come in to get a tree removal permit in case of weather calamity. So some quick examples of some things we've touched here. So the category of removal without permit, but with notice and approval, we've been doing that already. And the simple example is we've had some developments where there are trees next to them or in the woodlots that are dying or on an angle, and we've just literally told them, put a spray paint on the trees, all come out there, and it's usually that day or even the next day, and we just take the pictures and confirm, yep, those are dead trees, have at it. So that's relatively small, but it's a way for us to confirm things are happening without having to go through the whole process. Believe it or not, our findings and intent and purpose page was like 3 or 4 pages longer when we started. We did start cutting and honing it, making it a bit more precise. And that is something that as we incorporate that material into a master plan or an urban forestry master plan, we can probably cut it even more and just say goals and intents of these plans. There are all sorts of ways that we can dice it. For example, if the harm of removing a tree in a commercial area, we can argue that's greater than removing it from residential areas because commercial areas have a lot of hard surfaces. So the stormwater impact, the heat impact of that is much greater. So we could say if you're removing a tree on a commercial or industrial lot of any size, you got to get the permit. But if it's in residential or other zoning districts, maybe we have that different number. So know that there's all sorts of wiggliness in here, and we're trying to prepare materials to aid your discussion where you guys set that point.
Right, and I'm sure you're gonna, like you said, you got a big draft now, you're gonna hone it between the zoning plan and everything, and we'll get there. Yeah, thank you. Okay, go ahead.
Awesome. So as we're talking about ordinance provisions to either be modified or added to this additional revision to the current ordinance and everything, my team took a look at the International Society of Arboriculture, produced this report called Guidelines for Developing and Evaluating Tree Ordinances, which gives kind of like a menu of options of things that communities might find beneficial or might not, depending on their preferences in the issues facing the community particularly. Some of these suggested provisions are either already in place or being implemented in the draft revisions and everything, such as the explicit delegation of administrative and enforcement authority to township staff to be able to enforce the provisions of the ordinance that are being adopted. Additionally, something that some ordinances have is regarding civil tree disputes, whether that's trees impacting view sheds, whether that's trees impacting potentially leaning over somebody's property, some of those hazardous tree situations we were talking about. Some ordinances have that, and then some just have that generally in their nuisance provisions in general. Nextly, as we discussed, having that flexibility of options with these site-specific assessments and everything, clarifying kind of the bounds of that flexibility, for instance, adjustment of the particular trees by diameter or by particular site plan requirements or anything, adjusting between on-site and off-site mitigation based on what's most appropriate, kind of setting some of those boundaries for things that maybe the Planning Commission can use their discretion to modify within due process bounds. Next, talking about conflicts between trees and infrastructure. This was something that I definitely was not aware of before talking about this project. But when we look at the goals of tree preservation more generally, and we also look at necessary infrastructure like sidewalks, roads, sewer systems and everything, sometimes trees' root systems or just trees leaning in general can result in harms to that infrastructure. So kind of setting up this system of priority versus like, are we looking to put sidewalks around landmark trees, or are certain trees under a certain diameter acceptable to cut if we want to put in a sidewalk there? Or if, for example, a tree's root system is interfering with sewer service, when are the circumstances where we'd want to move the sewer versus taking out that tree particularly? So kind of setting those priorities as policy statements in the ordinance. Next, some ordinances, actually quite a few, have a definition of what's called a public tree, which, as the name would kind of suggest, is a tree on public property that's owned by the township and local government that the township has more rights over, that they're able to take down if necessary without permitting. That's very distinct from private trees that are on people's individual property that the township doesn't have those same rights over. Next, some communities have a tree board, kind of setting this policy, having these kinds of discussions for what's acceptable within the community, kind of serving as a go-between between stakeholders who might have concerns about tree regulations in the community and the government as a whole, making those recommendations for policy moving forward and everything, as well as sometimes they do celebrations for things like Arbor Day or community certifications and things. Next, we talked about hazard and emergency township tree removal. Definitely, as mentioned, with the storms and everything, that becomes certainly very, very prescient, especially with the advent of climate change, the increased frequency of these events, setting these standards for what becomes an emergency, a dangerous tree that needs to be removed, and what the steps are to be taken by the property owner in those circumstances. And then lastly, a couple of communities have something, a display of removal notice. So if it's, for example, like a large swath of trees, if it's a landmark tree, actually posting in that area that this tree is subject to potential removal and everything. And again, those are just totally like menu of options that if the township likes any of those, they're welcome to implement. There are also different recommendations that are included, different potential provisions that are included in that report as well too, for things that the township may add, may modify in their ordinance too. And then lastly, as we discussed, this might be obvious at this point, but having the mitigation determination and plan as a part of tree protection ordinances as a result of this kind of unprecedented litigation. Looking at firstly, the proposed mitigation plan, developing that with the applicant and everything. Once the township has done a few of those, kind of having this menu of options to be tailored to that site-specific assessment to show that that mitigation plan is proportional and justified, along with that schedule of fees that is proportional and justified as applied to a particular site. Again, that mitigation determination will result in those findings of fact to come from the township itself to show that the harm that's potentially being caused by the applicant's actions in cutting down a tree is being directly addressed by the mitigation that the township is requiring and showing how so and how it's proportional and reasonable. That's all that I have, but happy to answer any further questions or anything.
I want to just stress one more time, this, I think it's very important, given the litigation that you were all involved in, to satisfy the court that you're doing some kind of individualized assessment when you're requiring mitigation. And doing some kind of a mitigation plan and a determination for a property owner, telling them this is why we're doing what we're doing, is going to be really important. But like in most things, I don't think it's going to require a scientific study for every individual property owner. A lot of that can be boilerplate, where you're just doing the final check. Does this still work for this property owner? If it is, good. Here's the paperwork telling you why we're doing this. There was just none of that kind of documentation that the courts could find and look to in the prior litigation. So your concerns about creating administrative burden and who's going to administer, those are totally reasonable concerns and the additional burden and costs on property owners. But if you're going to value trees and take steps to protect them, it's way better to think through this process now and kind of do it right so that you don't get into a lawsuit again. People are comfortable with why you're doing what you're doing and it's reasonable. And I just have to point out, you've got two really good planners on your staff because they went to the University of Michigan's planning program and I happen to know them and they really know what they're doing. So a lot of this is just to say, keep going. You really are going to become the model that other communities in the state are going to know. How did you respond to what happened to you all that you got caught in some litigation? How did you respond? And you've got some great opportunity to do it really well here and become a model for other communities in the state that hit the right balance, protecting trees but doing it in a reasonable way. So that's my little bit of cheering you on. Yes, please keep going. You've got a chance to really do good things here.
So Patrick, we know that, I mean, obviously, this happened with the tree ordinance, but could you just give the group like an assessment about what you do now with development? Since we haven't gotten this new ordinance in place, how do you handle it when somebody comes to you?
Sure. So there's another section of the tree ordinance that is not under the mitigation section, but it's under our review standards and procedures. And it deals with the environmental factors of the site, the soil, whether there's wetlands, floodplains, and we look at the site itself. It's a section that has often been overlooked because a lot of the focus in administering the ordinance is just on the mitigation. You cut a tree down, you replace it based on whether it's protected or a landmark tree. And what we've done is we've leaned more onto the section that deals with the environmental factors of the site, the surrounding area, and the impact of the tree removal. And in doing so, we end up finding ourselves back to the mitigation. And in some cases, owners or developers have found it easy to mitigate the trees based on what they remove based on the formula that's in the ordinance. In other cases, we've worked with our legal counsel to come to agreements of doing some kind of mitigation based on that first section of the ordinance that we look at in terms of the environmental factors of the site and the impact of removal, and then associate that with any kind of mitigation. So in many cases, it's been a case-by-case basis where someone voluntarily opts to comply with the numerical standards of the mitigation, then we allow them to choose that option. Where someone proposes to do something different or something less, we've engaged our legal counsel to make sure that our review of that is still within the parameters of what we can do with our ordinance as it is today. So it's kind of a case-by-case basis. Most people have opted to replant according to the numerical standards of the ordinance because the mitigation is fairly straightforward. And when there's tree clearing and development, there's oftentimes a lot of opportunities in open areas to plant trees. And what we find, especially with smaller developments and homeowners, is that they're proposing to plant trees anyway. Sometimes they just don't know exactly where. So we work with them on that. And sometimes the landscape plan is forthcoming and we may hold a bond until that happens and the house is developed. So there's a number of different ways that we've approached it. But we've presented options both in the ordinance and then working with our legal counsel about other alternatives.
Other questions? Anyone?
Only thing I was going to say, I'd rather read the 6 pages. We used to call that boilerplate. Maybe we need it, but I would like to see what it says and see if it's overstated. So, no, I'm not, it's all good. I'm just going to say.
I'm not saying it's not necessary. I'm just saying it doesn't, I mean, it's just another way to put it. And I like the idea of putting that in the master plan. I think that's the appropriate place for it. Other comment I have about, in general, is as we go through the master plan process, we've identified, excuse me, some key areas of the township that we want to see developed. And a couple of them I have in mind that we've discussed, having a lot of tree cover on them. If we're gonna, and this gets back to the balancing again, if we want to promote development on certain parcels, then we have to make sure that we're not burdening the developer with these types of regulations. So again, there's a very fine balance there you're gonna have to find, I believe.
I think Patrick's doing that with how he's handling, how he just explained, right, on a case-by-case basis.
Yeah, and in the formulas and options that we're working with in the ordinance, right now, the ordinance is either replanting or planting offsite or paying into the tree fund. In our proposed ordinance, we're looking at more options and some of the environmental factors and some options that may be preferable. They might take a little bit more time and more effort on behalf of the applicant, but they may be more workable for a site. So from the beginning, when we started drafting the ordinance, our legal counsel has told us, one of the names of the game is allow for options, that it's not just one or the other, that there's multiple options as long as they're workable and that it has that rough proportionality. So, where there's a lot of tree removal, it may be where, replanting the trees is helpful, but there could be other environmental factors, like if those trees benefited for flood control, and if they can build a larger pond, there could be some offsetting factors that help with some of those. If the the trees that they take down may not have as large a canopy, but they plant fewer trees that will grow into a larger canopy based on the species. Canopy cover could be another thing that we look at.
Summer?
Just a couple of things. I agree with Commissioner Weber that I think we have to be flexible with how we are crafting the ordinances and make sure that we are giving folks options. So thank you for that, Patrick, and thank you so much for this presentation. I've learned so much that I think that I hadn't even considered. And, you know, as I was thinking through this and thinking about some of the other ordinances that we don't necessarily have justifications for those either. And so I don't know if this is a question for you, Patrick, or Deputy Supervisor, but like one of the things that popped in my mind was like the sign ordinance, and like we have reasons, and we've talked about the reasons at board meetings, and but they aren't necessarily spelled out in ordinances or master plan. So I think once we get through this, and we've learned a lot, but is there going to be any attempt to kind of clean up some of the other ordinances that we have?
Yes, the sign ordinance, we currently have a draft of that we're working through. There's a lot of federal litigation and revolving around the First Amendment with sign ordinances, and it continues to be active, and those are cases that we continue to follow at the federal level and within our circuit. It can be somewhat of a moving target, but the sign ordinance is something that we're getting much closer on, and that's something where that draft ordinance does have a lot of purpose and intent statements, maybe not 6 pages, but there are a lot of them for very good reasons. So a lot of that is, you know, it's several pages just because if it's subject to federal litigation, it's something of trying to go maybe over the top in explaining it just to initiate the people who will be litigating it or adjudicating it in terms of why we have the ordinances. So the sign ordinance, when that comes, the very first thing, purpose and intent statements, and there will be a lot of them. And as other ordinances come up, if they're not something that's going to be subject to as much litigation, we may have a much shorter purpose statement, maybe a sentence or two.
Yeah, I know, like, for planning commission, we spent a lot of time thinking about the different parts of the sign ordinance. And I will say, as a board member and a planning commissioner, I like the joint meetings. So just want to throw that out there.
Kill two birds with one stone. Can we just go from site plan approval at the planning commission right to the board approval right there? I'm sure the developers will do that.
Any other comments?
No, I just wanted to thank both of you for coming tonight. I thought this was really informative and really explained to us better what exactly happened, because I'm not sure there was a really good understanding of that. So thank you for coming.
Alan?
Yeah, I just wanted to kind of elaborate on one single point that Zach mentioned. You know, do we treat commercial differently? Possibly, but I'm thinking of the legal aspect of it. If we're putting forth a justification of why mitigation, why trees are important, and we're putting a formula together for mitigation, are we hurting ourselves by saying you're under 2 acres, you're exempt? You see what I'm saying? You're losing the tree still. You're losing that benefit, but we're saying it's okay because you meet an acre threshold. And what comes to mind is BJ's gas station. Wasn't that full tree cover under 2 acres?
Yeah, that, so with the 2 acres, the language of the ordinance is developed sites that are under 2 acres. So because it was an undeveloped site, it was subject to the tree ordinance. In that case, they had a lot of trees that were exempt because a lot of those trees had just grown wild over time and they were exempt species. That was one where they voluntarily complied with the numerical standards of the tree ordinance, where they were able to fit those trees on the site. And because it was part of a plan development and we were interested in having more screening. A lot of those evergreens that are out in the front there, some of those were mitigation trees where they were able to plant the trees on site, and over time, there's going to be some screening of the gas station from the adjacent areas while still being visible to the interior.
I was just thinking, you know, I don't want to set ourselves up with a developer that'll come in and say, well, you let BJ's do this because he fell under an acre threshold. Now, why can't I get away with that just because I'm a little over 2 acres? I guess we have to have answers to that, and we have to think about that when we're
You touched briefly, Patrick, on something I was thinking about. How do we differentiate between a landmark tree and what a lot of us affectionately refer to as the scrub trees that are just, you know, grow out of whatever? You seem to indicate that the BJ's property had a lot of that type of species, so obviously we got to make sure we clarify those issues.
Yeah, I think we do. We have a list of the trees and what are landmarks.
And speaking of those in the ordinance, right now we have a long list of landmark and exempt trees in the ordinance. As we get closer to approval, that's something that we may make a list by resolution rather than codifying it in an ordinance. So we could save a couple pages in the ordinance, and then from time to time, so if we get invasive species or something happens, we can quickly do a resolution as opposed to doing an ordinance amendment. So that's something where the ordinance is very heavy on text, but as we go through it, we may pull that out and make it more of an administrative document.
The other thing I wonder about, and I talked to you briefly about this in another context, I believe, when we were talking about something else, but it kind of touches on the whole idea of the time you plant trees. Having requirements that if somebody plants new trees, and I'm talking about a substantial number, I'm not just talking about a single tree, that they're responsible for taking care of it, making sure it's irrigated and that sort of thing. And my context for my question is, having spent a lot of my career in the wireless industry and having to go and having requirements put on my clients to have to put X number of foot of evergreens around the compound or whatever. However, and they go plant them without any regard to, okay, well, who's going to water them though, especially after they're initially planted. So there needs to be a care concern there once we require such plantings as well. And how that works, I'm not sure, but otherwise we're just going to end up with a bunch of dead trees.
There was something in the draft about that, wasn't there?
Yep.
Currently, and what we're working in the draft is a couple different ways to guarantee that the trees survive. One is a performance guarantee that we hold, and we come back 2 years later to make sure the tree has been established. And usually by that point, if it's got roots and it's alive, it's probably going to make it. The other new option we're looking at is allowing a portion of mitigation trees to count towards trees you have to plant anyways, with the idea site plan says we have to do these trees, they have to be there. So if it dies in 3 years and we roll up and 10 trees on the street or in the parking lot are knocked down, you got to put those trees back. And we're trying to do balancing of how does that work and how does that look, but we are looking at different mechanisms to making sure that the trees are there.
Are there any requirements put on anybody when they have to plant new trees about how they're taken care of at the outset? I mean, I hate having to wait 2 years to see whether a tree lives or dies or not. I mean, like you said, if it makes it 2 years, it's probably good. But, you know, it's just, and I'm just kind of spitballing, I guess, here at this point. But
Require all trees to meet our standards in the zoning ordinance for size and health and,
Right.
and how it's planted. And there's used to be American Nurseryman standards, but now they've merged American
So,
No.
there was an email from Emma Kramer that went out to HOAs about trees that I think, Zach, you contributed
Yep.
to. And there was a lot of information in there about planting and how to care for the trees. could that kind of information be included somewhere, if not in the ordinance and, somewhere else?
I would love to staple it to their shirt. We-
Can we include that with when to use
Yeah.
the blue bin
Yeah,
too?
he will. I mean, I know you watch the trees really good right now, too. You do. I know you have, right now, we had to replace some of the trees around the building because of that, so you watch them very carefully. Zach's very good. Thank you very much for your presentation. We're going to move on to public comment, so there might be more questions. But, so, public comment.
Good evening. Dan McCausland, sorry. Dan McCausland, 328 Haggerty Road. Couple things here. Listen to this tonight. Excuse me, this stupid thing. Listen to you here tonight. A couple things that stick out to me. I think the court did get it right. You say you were get caught, you did get caught. $464,000 instead of saying, hey, what we're going to do with the trees. It was all about money. Where is the audit of the tree fund? We've asked for that for numerous times. How much money is in the tree fund? Nobody wants to ever say. You know, the tree ordinance was started in 1994 by the clear cutting of Home Depot, which was, a big site. And then the administration at that time said, hey, we're going to have all these big developments coming in. We can get a lot of money off this. The troubling things that I see, words I hear, voluntary comply, level of harm determined, different definitions of harm, sweet spot of burdening the residents. Yes, we were caught. The name of the game. I don't like that kind of talk. Here's what I would propose. Any community that bases everything on trees, we should have an arbor crew. We should have our own arbor crew that goes out and maintains our own trees, public trees. You talked a lot about public trees. Trees that are being replanted, they're in the right-of-ways. I can give you numerous examples, but I only have a little bit of time. But those trees impact the walkways, the water courses. Nobody maintains those trees. If we're going to be a tree-based community, which I'm okay with, we need to have maintenance of the trees. Right now, that's put on the people who plant the trees or people who are replanting the trees. So that's got to be looked at. Then there has to be better regulation. The regulation, we're looking to us to set the bar. No, it should be a defined regulation statewide, not just locally. It should be regionally, statewide, and it should be a level that should all reach the legal nexus, as you're talking about. So what are we going to do when the next ash tree borer disease comes through? We got all these trees piled upon each other, and then all of a sudden, we're going to have a tree board, and this seems like we're so pro-tree, but we're all about regulation. How do the trees fit in with us? How do we all adapt together with the trees? If that case, I guarantee you, if a judge looked at that case and said, these guys took down X amount of trees, and you wanted $464,000, but if that money, that monetary amount was not in there, and they said, look, you had to replant 400 trees, I don't think the court would have sided with the landowner. They would have said, plant the trees, do something, come to a consensus. But the problem was, it's all about the money. Just like the gentleman said on the Planning Commission, it's all about the money. And Mr. Weber, I think that's a great thing that you said. We can't burden a resident. You can't burden a resident because all of a sudden they have a bigger than whatever this numerical number of acreage is. It's the unlucky lottery. A gentleman told me today, you're a victim of the unlucky lottery. That's not fair. We can't look at this that way. We have to look at this fairly, equitably, across the board. Put our heads together, come up with a consensus. It's not just about piling a bunch of trees on top of each other, and it's not just about collecting a lot of dollars. It's about making a community. I remember when they adopted a tree logo, they said, look, our logo's a tree. It has to be the best. We never lived up to that. It's been 30 years ago this year. We failed horribly.
Thank you, Mr.
Let's try to make it better for the next 30 years. Thank you.
Thank you. Did anyone else? No? Oh, we don't have that. Oh. Anybody else want to make final comments? No. Thank you very much for everything you did. Yeah, you worked very hard, and congratulations. I hope you get a good grade on your report. Has it been graded yet? No. No, we really appreciate it. I'm sure they will continue to work with you on this project, and this is definitely a project in progress, right? All right, can I have a motion to adjourn, please? Motion made by Treasurer Slavin, supported by Trustee Foster. All in favor, say aye. Aye. Opposed, nay. Meeting ended. Thank you.